Two criminal prosecutions, one prosecutor, outrageous conduct on both sides noted by federal judges. I'm going to pull it all together here on Tuesday morning on Legal AF. I'm talking, of course, about former FBI Director James Comey's indictment and that against New York Attorney General Letitia James. Two different judges, two different sets of lawyers, same result. Within the same 24-hour period that Magistrate Judge Fitzgerald ruled on his memorandum opinion of 24 pages that the prosecutors, the Department of Justice, and Lindsay Halligan committed abuse of prosecutorial discretion, abused the process, and therefore turned over all of the grand jury materials normally secret to the defense, finding in his review of the grand jury materials that Lindsay Halligan, who was just a federal prosecutor for about 24 hours, committed at least two cardinal sins, violating the Fifth and Sixth Amendment rights of James Comey when she presented the case for the first time to a federal jury. But that's in the morning. By the afternoon, we have the new filing by Letitia James's lawyers, the New York Attorney General, and they're calling it the way they see it. This is a motion to dismiss the indictment for outrageous government conduct. I couldn't put it any better. I mean, within it is vindictive prosecution, but they go further. In fact, if you just read their table of contents, it tells you the entirety of the case, although I'm going to dive in here for you on Legal AF on Tuesday. While I do, hit the free subscribe button as we continue our march to 1 million subscribers. Background section, transforming the fair housing or the Freddie Mae and Fannie Mac organizations into a political weapon. Outrageous conduct at the Department of Justice. Ed Martin's outrageous conduct is one aspect of their attack on the indictment. The second is Lindsay Halligan. And listen to how they describe Lindsay Halligan, the quote-unquote purported U.S. attorney for the Eastern District of Virginia. They say that Lindsay Halligan, her only credential is loyalty, is installed at the as the U.S. attorney, and they ignore evidence as they get an indictment returned. There were actually, for Letitia James, there were actually two grand juries looking at this issue. One in Norfolk, Virginia, one in Alexandria. The one in Norfolk, Virginia was led by Liz Usey, who has been fired by the Department of Justice, career prosecutor, head of the Major Crimes Unit. There was grand juries looked at these issues. The niece of the Tish James testified, and they did not return an indictment. Yet those records, that information, that countervailing evidence should have been presented to the grand jury that Lindsay Halligan pulled together in Alexandria, Virginia. And it's this disconnect between the Norfolk, Virginia, the Norfolk grand jury and the Alexandria one that's at the heart of this motion. Why wasn't the Alexandria, Virginia a grand jury told about the findings or the evidence or the witnesses or the documents in the earlier grand jury on the exact same matter? What were they hiding? Obviously, that's the demand for the grand jury material. That's a subject of a separate motion. But they also drilled down on two key people as part of what I see as a description of a conspiracy led by Donald Trump, Pam Bondi, Ed Martin, who's the head of the weaponization committee of the Department of Justice, and Lindsay Halligan. He starts with, as part of that conspiracy is also Bill Pulte, the Nepo baby who runs Freddie Mae and Fannie Mac, that ended up probably illegally obtaining certain pages of information about Letitia James's mortgage on a $118,000 house she bought for an investment that she keeps her family in and that she uses as well in Virginia. Nothing wrong with that. They start with Ed Martin's outrageous conduct on pages 6 and 7, and I will post this document over on, as I do always, on Legal AF Substack. Ed Martin, they say on page 6, who according to his letterhead is U.S. Pardon Attorney, Special Attorney for Mortgage Fraud, Associate Deputy Attorney General, Director of the Weaponization Working Group. That's some letterhead, folks. Has engaged in well-documented series of actions that can't be described as anything but outrageous, they say. They include in this that he sent a letter to the Attorney General's counsel demanding that she resign from office back in August, and it would serve the good of the state and the nation. The letter was not an attempt to investigate facts. It was to pressure her to resign or, extortive, face criminal prosecution. They say that the letter by itself violates Justice Department rules, the principles of federal prosecution, and various other rules of ethics. Special attorneys, like the Department of Justice attorneys, are supposed to be objective in either seeking the facts and applying the correct law. But they say that in August 14th, he performed a bizarre media stunt where he put on like a Columbo overcoat in the middle of the summer in New York, some sort of trench coat, like he was Inspector Gadget. And he started walking around for a photo opportunity, trailed by the New York Post photographers. He got caught trying to look at where her brownstone is in Brooklyn by a person on the street. Here's a clip of what they're talking about in this new motion on page 7. Let's play the clip.
Why won't you be honest with me about what you're doing? You are acting suspicious on my lawn in front of my neighbor's home, and you're not telling me what you're doing. That's not true.
Interesting houses. It's an important house. So, thank you.
It's not. It's just like every other tract house on this block that was built by developers.
Right, they're beautiful. Beautiful neighborhood.
Thank you.
Michael, this is just strange. Walk us through that scene that we were just witnessing there.
Well, I thought it was even more than strange because Ed Martin is a Justice Department prosecutor. He, whether how seriously people take him or not, he has been given the investigative powers of the federal government to look into crimes. And for someone like that, in that position, with that extraordinary power, to simply show up at someone's home who he is investigating. There's no evidence he had a search warrant. There's no evidence that he had a subpoena with him that day. But to only be there, essentially, there happened to be a New York Post photographer there who captured him there. We've seen footage that was obtained through a surveillance camera that showed him posing in front of the home and in sort of menacing the individual that he is investigating. And it's part of a larger pattern by the Trump administration over the past 2 months in which they have essentially harnessed the vast intelligence gathering and law enforcement powers of the federal government to tar the people they don't like, the Trump's perceived enemies. And to simply show up at someone's home as a federal investigator, I just thought was, in the Trump era, we obviously run out of adjectives, but I thought it was pretty extraordinary.
Sounds like the Attorney General, Pam Bondi, not pleased with Mr. Martin's actions here.
Yeah, I think in normal times, if someone like a prosecutor like this went out and did this, they would be fired. There would be internal investigations at the Justice Department. There may even be Inspector General investigations. But for Bondi and Todd Blanche, I don't think that they have the power to get rid of someone like Ed Martin.
Again, he's trying to intimidate, harass, and stalk the Attorney General of the state of New York, not trying to get to the bottom of facts in a neutral way. And so this violates, including the local criminal rules of the district, that a lawyer, quote, and this is the rule, a lawyer participating in or associated with an investigation shall refrain from making any extrajudicial statements. That means outside the courtroom, which a reasonable person would expect to be disseminated by means of public communication that goes beyond the public record. Hence the New York Post reporter that was with him. Then they turned to Lindsay Halligan, who I just love this phraseology. Her only credential is loyalty on page 9. And that's fair. I call her Insta prosecutor. I say that she is the novice, and that's being kind to novices. That's been insulting to novices. She was a automobile insurance lawyer, fender bender lawyer in Florida. I don't think she ever went to federal court. Those lawyers don't usually do anything in federal court. I don't think she's ever been in federal court. She certainly was never in front of a federal grand jury before until her first time, where she was left twisting in the wind, pushed out onto the plank by her own boss, Donald Trump. Nobody from the Department of Justice in Washington went with her. Nobody sat with her. The person that was with her, Megan Cleary, got fired already. They say here's what they say about Lindsay Halligan. Effectively, that she ignored evidence that would have been against her case against Letitia James. That there was evidence created by her predecessor, by Liz Yusi, the major crimes prosecutor. Every career prosecutor in the office gave her a memo that said they should not indict Letitia James. They say on page 10, Reports indicate that in the Oval Office dining room, Director Pulte told the president that Siebert had been picked for the U.S. attorney position and was blocking charges against James. That led on September 20th to President Trump posting what he thought was a message directly to Pam Bondi, apparently, instructing her to indict Letitia James and to use Lindsay Halligan for it. On page 11, 48 hours later, Lindsay Halligan was appointed. Liz Yusi was fired. Megan Cleary was fired. And then they go through the outrageous conduct, including keeping from the indicting jury information that would have undermined the indictment that was developed in the Norfolk, Virginia jury. Now, they don't mention per se the earlier ruling. I think these kind of passed in the night a little bit by Judge Fitzpatrick in the Comey case on the same day, in which he said, I looked at the grand jury material. I am going to turn it over to the defense because I think there's impropriety of a constitutional dimension that needs to be pursued by the defense. So he took the cloak of secrecy off of the grand jury documents and turned them over to Comey. Now, on Letitia James, they're seeking the same thing. They have a companion motion that just went up, her motion for disclosure of certain grand jury materials, filed at the same time today as well. I'll cover that in a separate hot take, but suffice it to say that they are claiming that there was likely procedural irregularities in the way the grand jury was instructed by Lindsay Halligan, just as Judge Fitzpatrick found in his review. Now, these grand jury transcripts, the one I'm talking about here, have already been reviewed by Judge Curry, a separate judge who is handling just the sole issue of whether Lindsay Halligan should be fired for being illegally and improperly appointed as the U.S. attorney in the Eastern District. She's asked for the full and complete grand jury transcripts, but as you might have heard, not only did she not get them all, not only last week in her hearing did she pound her table as a judge saying, you are missing at least 2 hours of transcripts. Then Lindsay Halligan made it worse by filing what could only be described as a false statement under oath to the federal judge saying, oh no, that 2 hours, I wasn't dealing with the grand jury. I never had any more interaction with them. They were deliberating. And Judge Fitzgerald in the Comey case said that can't be true. One of two things can't be true, because she had to get a second indictment brought back to the grand jury, and there's no evidence, there's no transcript of the second indictment. She came out of the room with 2 indictments. One was allegedly true, one wasn't. How'd she get the second indictment? She must have had to go back in. Where's the transcript of her going back in? That's what they're trying to get to the bottom of, to see if any of that happened in the charging of the jury and the instructions given to the jury and the answers given to questions by the grand jury by Lindsay Halligan in the Letitia James indictment for mortgage fraud brought, a week or 2 later. I mean, let's be honest. She screwed up the first one. She violated, the judge found that in the Comey case, she violated the 5th and 6th Amendment, that she gave instructions to the grand jury that indicated to them that Comey, for instance, had to testify. And if he didn't testify, that it would be adverse to his position, which is the exact violation of the 5th Amendment against self-incrimination. He has no duty to testify. And then she made it worse, apparently, by also telling the grand jury in response to questions in the Comey case that almost like shifting the burden is always on the prosecutor, always on the government to prove beyond a reasonable doubt the crimes. The defense has no obligation. The defense doesn't even have to put on a defense. It's up to the prosecutors. But she flipped it and shifted the burden, which got the Judge Fitzpatrick upset. And was also grounds to dismiss the indictment, because if she did that, she led the grand jury to believe that he had some obligation to prove his innocence against the evidence. Crazy. If she did it there, she did it in the Letitia James grand jury. She didn't learn anything. There's no learning curve. There was nobody next to her to teach her. As I've said before, I'd never said at a young lawyer to go handle their first trial, their first grand jury, their first defense, their first deposition, their first small court hearing on a motion for discovery without having a senior lawyer or me sitting next to them. She went by herself. And that's what they're trying to get to the bottom of. And they say point blank at the end of this motion that the court should dismiss the indictment for all of these abuses. This is what they say. The government's conduct has offended the very core of due process principles by completely reshaping a government agency to investigate Attorney General James, flouting ethical rules and norms of investigation, threatening AG James with indictment to force her resignation, and violating statutes and the separation of powers. The charges she now faces are inextricably linked to the government's illegal and unethical investigatory techniques, its outrageous conduct jurisprudence that demands the dismissal of the indictment. And she also wants discovery about the charges that were brought against her. She wants all communications between and among Trump, Bondi, Halligan, Martin, Director Pulte, and the staffs regarding James. And they want to know how Director Pulte got access to Attorney General James's loan file. That hasn't been produced, and a bunch of other things. This is not going well. Let me summarize it this way. To say that the indictments of Comey and Letitia James, led by a novice 24-hour federal prosecutor masquerading as a U.S. attorney in Lindsay Halligan, to say they're on life support would be kind. I think they're beyond repair. I think we're just watching the nails of the coffin, and within less than 30 days, I believe these indictments will be dismissed. I'd be shocked if these cases go to trial in the beginning of January. I'd be shocked if either Judge Curry, I'd be shocked if Curry didn't find that Halligan was illegally appointed. I'd be shocked if the underlying judges who handle the trials of this case, Judge Walker, Judge Nachmanoff, Judge Fitzgerald, the magistrate judge, I'd be shocked if they didn't dismiss the indictment under any of these grounds. The violation of the grand jury process, the violation of constitutional law in the grand jury process, the vindictive prosecution, the outrageous conduct, you name it. This is the Trump administration once again is playing with it's not even Russian roulette. There's bullets in every chamber. And that's where we are. I'll continue to follow it. I'm glad you're here on Tuesday on Legal AF. Hit the free subscribe button. Come over to Legal AF Substack and do the exact same thing. Till my next report, I'm Michael Popak. I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.